with prejudice.
That would be denied. So I am going to, at this time, review for probable cause.
Object. Again, I've challenged the jurisdiction, and jurisdiction must be proven.
It's not going to happen today.
Jurisdiction must be proven.
To hear the charges, and I will be reviewing for probable cause, and then we'll make a determination as to whether or not you will remain in custody. And I will hear from the prosecutor as to that.
And if you violate my rights even further, ma'am, as well as the officer and the sergeant that violated my rights, who are also going to be getting sued, it would just add to that. And I don't think that you need to go that route.
While I review this incident report. All right, I do find probable cause with the charges. I will be entering not guilty, please.
Ma'am, you cannot practice law from the bench. I object.
Noted.
You cannot enter a plea for.
The judge shuts down the dismiss with prejudice request. That's huge. A dismissal with prejudice would mean the case could never be refiled. Instead, she pivots to probable cause, which is just a low threshold. Is there enough basic evidence to move forward? Not guilt, not innocence. Just enough to keep the train moving. And already, you can feel this is about to turn into a jurisdiction.
Somebody that is, practicing bench from the law.
Unless you want to enter a plea of guilty, today there'll be a plea of not guilty. I understand you are objecting.
Ma'am, I object. I challenge the jurisdiction. Jurisdiction has not been proven. Status.
There it is. Probable cause found. Notice how calm the judge stays while he's escalating with threats of lawsuits. Legally speaking, jurisdiction in a municipal court is usually straightforward. If the alleged offense happened in that city, the court has authority. But he's leaning into a sovereign-style argument. Challenge
has not been proven or established. And once again, you haven't even established, your nationality or your status. I am a non-U.S. citizen, American national by way of America Samoa. I reserve all my rights.
Is this something that we need to consider a competency evaluation for?
We may need to consider ordering ability to proceed, but it looks like you have a driver's license that recently expired.
To question my competency because I'm establishing status and asking you to prove jurisdiction is outrageous. And so.
Clarification. When a defendant refuses to enter a plea, the court automatically enters a not guilty plea on their behalf. That's standard procedure. It actually protects the defendant's rights. So this isn't the judge practicing law from a bench. It's basic courtroom mechanics. But emotionally, you can see he feels overridden, and that tension is only building.
Again, if jurisdiction cannot be proven, I move to dismiss this with prejudice based on the grounds that you cannot prove jurisdiction.
All right, I've reviewed this. You were driving in the city of Lake Forest Park. You were violating
again.
laws.
I was not driving. Again, I have rights.
You were behind.
And my rights were violated. My rights were violated. My right to travel freely unencumbered was violated. There was no emergency in which the officer needed to put on his red and blue lights. And so, again, if status cannot be set, jurisdiction cannot be proven, I move to dismiss this matter with prejudice.
That's denied. So you've made your record. Right now, I'm going to directly appoint counsel from the bench. Ms. McDonald.
Again, I am sui juris in propria persona. I stand on my 2 feet. I'm in my proper person. And so I reserve all my rights.
I understand that, and I've acknowledged that. I'm not dismissing your case today. I'm going to hear from Ms. McDonald as to the city's position on release.
Yes, Your Honor. I am going to be asking that the bail remain the same. It looks like it's currently set at $2,000. I do have some concern regarding his willingness and ability to reappear if he was released.
When a judge mentions a competency evaluation, that's a turning point. That's not about disagreement. That's about whether someone understands the proceedings and can assist in their defense. Raising complex sovereignty arguments doesn't automatically mean incompetence, but when arguments spiral, and disconnect from legal reality, judges sometimes start asking that question. Do you think that was warranted here?
On his own recognizance, as well as concerned about community safety and risk of reoffending, given his temperament in the court today.
And Your Honor, Mr. Schuster would ask the court to release him on his own recognizance. These are not violent offenses. I don't see that he has any convictions for violent offenses. There was an assault in 2021 that was dismissed. He may have a view of the law that is different than the city's, but that in itself does not indicate that he won't come to court or that he would in any way try to subvert court proceedings. So we'd ask the court to release him on standard conditions.
Well, the court can consider whether or not Mr. Schuster is likely to reappear for future court hearings. What I hear from him today is that he completely objects to this court having any jurisdiction. I don't have a good faith basis that Mr. Schuster will return if I were to release him. I do see that he has a prior conviction for DUI. He's on a deferred prosecution at this time in Seattle Municipal Court. He's not complying with conditions if he's driving without a license and driving without a required ignition interlock device. Also, indication that Mr. Schuster will not abide.
Now we're in bail territory, and this is critical. Bail isn't supposed to punish someone. It's about two things. Will they come back to court? And are they a danger to the community? The prosecutor is pointing directly at his courtroom behavior and prior history to argue risk. Notice how what you say in court can immediately impact your freedom.
The court's orders to appear on his promise. I want to look at the Seattle Municipal case and see when he's next scheduled to appear.
Like you had mentioned too, in 2021, same situation, or not same situation, a situation occurred in which they tried to charge me. They didn't have jurisdiction. It was dismissed. And again, I don't want any charges against me because I do have the deferral, which would obviously violate that deferral. And so I will make any visitations, special visitations to the court to handle any matters pertaining to Jonathan Troy Faifale, also Malietoa Schuster. I'm a man, I'm free, and I want it to stay that way.
I do see it looks like he's got at least 3 prior warrants. He has 2 priors out of Benton County, 1 out of Lower Kittitas. The previous warrants history.
And throughout this process of going to courts, I've had to learn a lot. And so I know it's no game to just not show and make visitations. That's not what I want to do. And again, jurisdiction does need to be proven, whether it's...
And that seals it. The judge bases a decision not just on today's arguments, but on prior failure to appear history. That's devastating in bail hearings. Once a court believes you might not return, release becomes much harder. Here's the big takeaway. Legal strategy is one thing, but credibility? That can make or break you in moments like this. Was this a principled stand on jurisdiction? Or a tactical mistake that cost him his freedom today?
Today or another date. And if you want to violate my rights even further by not releasing me on my own recognizance, ma'am, was it Jennifer Grant? Then, like I had mentioned earlier, you, along with the officer and sergeant, who are already going to be getting sued, I mean, there's no need to add you as well, especially when you know the law.
I don't see another date set until February 12th of 2025 in the
Seattle Municipal Court.
Yeah.
Well, Mr. Schuster, I have to do what I believe is appropriate in this case, and that is to set bail. And any threats to sue me or to take any action against me. I can't be swayed by that. So
It's
you
not
can
a
do-
threat. It's just what it is. My rights have been violated,
you can
and
do
if my
what you
rights are
need
going to be
do.
furthermore violated,
$2,000. I do not believe that you will respond to the court's order to come back. I do base that upon the conduct in this case as well as the prior